Great, thank you. Well, hello, everybody. Good afternoon. The time is 12:30, so we'll call the meeting to order. This meeting of the Board of Chiropractic Examiners Licensing Committee is being held by teleconference in accordance with the provisions of Government Code Section 11123.5. Committee members are participating virtually today from remote locations, and board staff is present at the following primary physical meeting location: Department of Consumer Affairs, the El Dorado Room, 1625 North Market Boulevard, Suite N, 220, Sacramento, California, 95834. The date is Friday, December 5th, 2025, and the time is 12:31. The board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, engagement, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes unless, in the discretion of the committee, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items except to decide whether to place the matter on the agenda of a future meeting. Please be aware that this meeting is being recorded, and please turn off or silence all cell phones. We will now take roll. Ms. Cruz?
Dr. Daniels?
Present.
Ms. Cruz, present. We have quorum.
Great, thank you. Moderator, could you open up agenda item number 2 for public comment for items not on the agenda?
Sure. This is the moderator for members of the public on WebEx. If you would like to make a public comment for items not on the agenda, please click the raise hand icon, or if you're an audio-only participant, you can raise your hand by pressing *3 on your device. I'll pause a moment to allow the public time to access these features and submit their requests. In the meantime, I just want to double check that there is no public in the El Dorado room.
That is correct. There's no public here.
Perfect, thank you. And it appears there are no requests for public comment on WebEx.
Okay, great. Thank you, Sarah. Also, I don't know if we need to do for the record, there's no public member at my location. No, we're good. Okay. Moving on to agenda item number 3, which is review and possible approval of committee meeting minutes. And those dates are August 25, 2023, March 8th, 2024, January 9th, 2025, and June 13th, 2025. At this time, I'd like to open it up to the committee if there was any comments or notations on those meeting minutes.
None for me.
Okay.
It was a nice refresher for a lot of the topics for today.
Yeah, right. So thank you, staff, for knocking those out. It was like a trip down memory lane, but it was very helpful. So I do have one question on 1.9, and I apologize, I'm going through different screens for the electronic portion. We had asked staff to begin tracking the licensee populations in other states. And I was just wondering if that was still in the mix to be done or had been done. It was in the conversation thread of, I think it's 58% of California licensees have been in practice for more than 20 years. I think we're losing about 100, 150 licensees per year. And we were interested in looking at the trends in some of the other states, I think maybe some of the bigger states. Ms. Walker?
That was an item that it's still on the to-do list that we've got to get done. Where we left off on that item was Dr. Paris was actually going to help connect us with a few people through FCLB so that we could kind of get those direct contacts. So we will definitely take care of that, but it's still an outstanding action item.
Yeah, it's not urgent, but I do think it's something we want to keep an eye on and check. And I think it falls into some of the other topics that we're going to discuss. So we want to keep our eye on that. So if there's no other comment before opening it for public comment, I'd like to make a motion that we approve the committee meeting minutes for August 25th, 2023, March 8th, 2024, January 9th, 2025, and June 13th, 2025. Is there a second?
On mute. I second, sorry.
Thank you. Okay, moderator, could you open this up for public comment, please?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click that raise hand icon, or if you're an audio-only participant, you can raise your hand by pressing *3 on your device. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and it appears there are no requests for public comment on WebEx.
Great, thank you. Ms. Cruz, can we take the roll for the vote?
Dr. Daniels?
Yes.
Ms. Cruz? Yes. Motion passes.
Great, thanks. Okay, moving on, agenda item number 4. Ms. Walker, if you could provide us with an update on the licensing program.
Sure. So few updates that I want to share on the licensing program. The first of which is I'm happy to report that our licensing unit has been fully staffed now since July of 2025. Staff have been really focusing on training in the core operations and functions of their jobs, and also learning the different transaction types that we have. As we head into the new year, we're going to shift that focus a little bit onto having them build on that knowledge and integrate a little further into a lot of the project-based work that supports this committee and our Connect project, our business process improvement opportunities, and then also having them assist with monitoring any licensing related legislation that we may see get introduced around February of next year. To that end, I also wanted to take a moment to thank the licensing team and really acknowledge them for their hard work. We had within probably about the last year or two, we had been really working on developing business process improvements that we can make to our licensing program to really get our processing times down and be able to get through applications much quicker. And this team's really been carrying those out. You can see that when you look at page 5 of the program update, where it shows kind of a brief comparison of our licensing statistics in this current fiscal year compared to the past 2. And you can see that trend of reducing processing times for both our initial and our renewal applications. Where we want to work on building on that effort a little bit further is when we look at our processing times, particularly for initial applications. One of the issues that keeps that number, it's a good number, but what keeps it a little bit higher is just incomplete applications. So as we head into next year, we'll be working on targeting website content, outreach, individualized communications to where we can try to reduce the number of incomplete applications that we receive for our initial application types, particularly the DC license. And then also, as far as the Connect project, I'm happy to report that our planned upgrade to getting on the newer version of the platform is back on schedule and will be coming soon. As of right now, the vendor is ready to support the effort, and DCA's Office of Information Services is working on completing their documentation of our existing workflows and data mapping so that we can prepare for the project and ensure that any functionality that we have in the current system carries over when we upgrade to the new platform. So we do expect that project will be starting relatively soon, and then they're anticipating about a 6-month timeline for completion. As far as IT projects, we're also working on redesigning the website. We've gone through and removed actually quite a bit of obsolete content that was on our board website. There's something about 300 to 400 items that have already been removed just because due to age, and they're not necessarily needed anymore on the website. Our next step is then to get our new content for consumers, applicants, and licensees on the website. We do expect to have that new content ready by January. And then from there, the next step is for us to redesign and move to the new version of the state template, which is targeted for completion by March. Also within the program update in the meeting materials, I placed some of the key legislative deadlines that are coming up. The ones I wanted to note here today that are important is January 16th is the last day for policy committees to hear and report fiscal bills that were introduced in 2025. And January 31st is the last day for the legislature to pass bills that were introduced in their House in 2025. Where that's important is the animal chiropractic bill, SB 687. That bill needs to get out of committee by January 16th and pass through the Senate by January 31st, or it's essentially dead. A few other items I wanted to provide an update as well on our regulations. So I'm happy to report that we are making progress on our regulations. Most recently, on Monday, the Office of Administrative Law approved our Section 100 filing to update our fee amounts in regulation and also make some minor cleanup revisions to text. OAL also approved our filing of addresses and contact information package on October 14th, and that new regulation will become effective January 1st. We're working on Connect enhancements to be able to fully implement the requirements from that filing of addresses and contact information regulation so that we can effectively collect the new addresses as they're formatted in the regulation, but also phone numbers and email addresses. And we're planning to kind of roll that out as part of the renewal process to make it very easy for licensees to comply. They'll have the information when they go in to renew. They'll be asked to verify their contact information during that transaction type without requiring too much on their end to come into compliance. We also have 4 licensing packages in the production phase. Staff internally, we're wrapping up the approval of the DC programs, and that now includes the initial licensure process because that text overlapped. So those have been bundled together. We're also working on the renewal and restoration of DC licenses and the basic life support requirement. We anticipate that those will be going to DCA Legal and Budget soon for approval, and we're estimating around February of 2026 to be releasing those packages out for public comment through OAL. We also have the prohibited activities by inactive licensees package, which the budget office is just wrapping up their approval of that package. So we're anticipating that one going to the director probably within about the next week to about 10 days. We also have our repeal the mental illness regulation that's obsolete package was actually just approved by the director yesterday. And it's been approved and it's been sent to agency. So we're looking at around mid-January for that one to be filed through OAL. We also have 4 remaining regulations in our concept phase. 3 of those are the next 3 agenda items on our meeting agenda today. And then we're also going to be working with our lead analyst, Amanda Oppo, to get that survey out for retired licensees so that we can make some progress on that remaining item. So that bit of a lot there that I covered, but that's my update, and I'm happy to answer any questions about the licensing program.
Yeah, that was great. And I don't know where it came from. I know I mentioned it, but thank you for whoever did the bar graph. Excellent. Thank you. And thank you for everyone's work on kind of trying to move these packages forward. I feel like we're kind of finally getting that going. I don't think I have any other questions or comments unless, Ms. Walker, I was looking at the stats for initial DC and satellites and renewal, and this 2024 to 2025 looks better. Is that just because of where we're at in our cycle, or is it improving?
Overall, when it comes to the processing times, we're actually beating them in 25, 26, except for the corporation processing times are up by a day. And that's just those corporation applications are the most incomplete of all the application types that we get. So that becomes a little out of our control. But as far as the actual numbers of applications that we're getting, we're actually outpacing last year just a bit on new satellite certificates. We're slightly behind on the DC licenses, but that's because our highest volume of new DC licenses is actually in the spring. So overall, we're kind of, I would say we're pretty comparable to last year. We do need to run some data just so that we have a better estimation when it comes to the DC license renewals, breaking it down licensee population by birth month, so that we have a better basically measure of the flow of those incoming renewal applications, because they're not spread equally over 12 months. So when you gauge 4 to 5 months of data, it's not necessarily always going to be just a third of what we expect the total. So we'll get a little bit better metrics around that.
Yeah, I think getting metrics on that, and then also I think this is where just kind of the population differences would fall into this, kind of how many years they've been in practice would be helpful. And I do think the stats are August, September, and October have the highest birth rates. So there is actually stats on that, and there's obviously a particular reason for that. So it'd be interesting if it kind of fell in those months. Ms. Cruz, go.
Yeah, oh yeah, kind of, I was looking at the exact same data in my notes here of if for looking at the bar chart, specifically looking at the groups that because clearly in the initial DC there's clear utilization of the Connect system. We've definitely increased utilization in 24, 25. Do we have any specific demographic information behind kind of those who are not utilizing it? Is it, are we seeing that it's, what's it called? Those who've been in had their license for much longer, or right? So they're kind of very set, like this is how we do it every year, or just if they're just thinking of how we target the behavior.
That's an excellent question. We don't have the data yet, but we have the capability of getting it. So as we're kind of expanding out those metrics, that's something that we can definitely pull, is looking at what portion of the licensee population is using the system versus not. And then, that way we can target how we're going to improve it. The other item of note is come July of next year is when we're phasing out sending those renewal packages, and instead you're just going to get a postcard reminder. So, I mean,
Okay.
in a sense, that's almost going to force a lot of users to use Connect, because otherwise you're going to have to go online and print a form and mail it to us. So, we are anticipating that rate is going to significantly go up, but we'd like to get it up before we get to July anyways. So we'll take a look at that data.
And I'm guessing also for the incomplete applications, I imagine those are not in Connect. There are ones that are just submitted.
They actually are in the incomplete satellites aren't an issue in Connect. It's not really an issue overall, but and neither with the corporations are not in Connect, but the initial DCs, the majority of them are in the majority of those are in the Connect system, but they're incomplete due to kind of the timing of how applicants kind of engage with the system. They'll put their application in, but then they haven't released their NBCE scores to us, or they haven't ensured that their school is sending their transcripts. So we end up with any number of different scenarios where we've got a partial application. So we want to try to use the web content to try to drive what you need before you start your application. Do these things like go online, go into your NBC account, release your scores to us, so that we can eliminate those backlogs.
Yeah. Okay. No, that's good.
Ms. Walker, should we restrict it to that before they can upload, you have it written out, these are the steps you need before you initiate the application?
That's what we want to incorporate in there. We do have within the application itself, they do certify that they've made the request, but we kind of find that, sometimes they're making the certification, but they're almost doing that in advance, and then they haven't actually
certify I'm gonna.
Yeah, exactly. I certify I'm going to take care of this versus I've already done it. So, and it's one of those things where it's like they drive the timeline themselves, because our processing times are fast. It's just we need all the pieces so that we can move them forward. But we want to try to encourage them to,
Okay.
that
was one of my next question is like, when does the clock start? So the clock starts at least when they start engaging the system. So that makes sense why it's.
Yeah.
But if it's not clear on the website, I guess I'm suggesting having, like in bold before you start the application process, make sure you have bumpty, 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 bump, just as another initial reminder before they engage.
Yes, that's what we're working on as far as content. We want to have like a nice, clean, easy to follow checklist of what to do, and then we're also going to incorporate that as well into the instructions on the application. So even when you log into the application, the first screen you see is going to be that checklist before you even start an application. So we're going to put it in both places.
Perfect. And then I'm wondering, should we, or is it possible, should we engage the schools with giving
that was
them
my next
content?
one. Yeah.
As far as, here's the cheat sheet, and give it to them ahead of time, and whoever's in charge of, I don't know if it would be clinic or, wherever they're at, so that they can facilitate it from there as well.
Yes, we will definitely do that. The schools have done a great job with getting with kind of guiding their students, especially the California schools, getting them licensed here. They do an excellent job of guiding them through the process. We find the issue more from people, not the immediate graduates, but people that waited a little bit and then they're trying to get back in, that tend to have more of the incompletes.
Okay. Anything else, Ms. Cruz?
Let me see here. Complete applications. The Connect. For Connect, one is you mentioned that given the updates to the address, phone, email requirements, when would that be effective in Connect? Just didn't hear an effective date.
It's in this current build that's going on right now. So it's going to go live right around the beginning of the year is when it's going to go. It's going to go live, and then it's going to be incorporated in the renewal application. And then also they're making updates to the licensee's profile section, that portion as well, so that they can update their information there.
So fair to say January?
Yeah.
Okay.
Yeah, it's going to be released in January, and it's going to be one of those where coinciding with that release, once we get it to test, we'll work on the messaging that's going to go out to licensees as far as what's changed, and then also how they come into compliance. And it's going to be one of those regulations where it's more about information and getting people into compliance rather than like a heavy hand as far as enforcement. We're going to give it a year, 18 months to come into compliance before we really start enforcing it at a stricter level.
Okay, thank you. That's it.
Okay. Moderator, can you open this agenda item up to for public comment, please?
This is the moderator for members of the public on WebEx. If you would like to make a comment on this item, please click the raise hand icon, or if you're an audio-only participant, you can raise your hand by pressing *3 on your device. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and it appears there are no requests for public comment on WebEx.
Okay, great, thank you. Any more comments before we move on to agenda item number 5? Okay. Okay, so agenda item number 5 is to review and discuss and possible recommendations regarding the regulatory proposal to clarify the requirements of Doctor of Chiropractic licensure by reciprocity and create a new temporary licensure process for applicants who hold an active unrestricted license in another state. Ms. Walker, if you want to start off, that would be great.
Sure. Just some brief background information on this regulation. So the committee in prior meetings had discussed the issue of reciprocity and basically concluded that, after looking at separately building all of the California specific curriculum requirements that we have, and that entire undertaking of putting that regulation together, in consideration of that, the committee had concluded that all licensees who receive a DC license in California should meet those requirements. And then the gap in between was, well, we need to build something to where somebody who's already been licensed in another state can come in, begin practice with a public notification requirement while they meet any deficiencies that they may have in their application. So that was kind of balancing both, rather than doing some sort of model where it's a endorsement or true reciprocity where you just accept, a license for another state, you automatically get a license here. That was the prior discussion. we've got some pretty conceptual language that we've put in the materials that we're requesting some discussion from the committee today. What that language really does is it clarifies the requirement for reciprocity in the sense that it clarifies that an applicant seeking licensure through reciprocity has to comply with the same requirements as any other applicant, except that, and we had put some language in here about waiving the national exam requirements if the applicant can provide documentary evidence from another licensing jurisdiction showing that they have equivalent successful examination in each of the subjects examined in California at the time they were issued their license in another state. That's existing regulation as it stands now. And then we've gone in and basically just deleted all of the other text because it's unnecessary and just redundant to what we're doing now. And then we've also added some language around the application and eligibility requirements for a temporary license. And this is one where we're just kind of putting an initial concept out there. We'd really like some input from the committee on what those parameters may be. But generally, what we've put in here in this initial round of it is to qualify for a temporary DC license. The applicant would have needed to graduate with a DC degree from a board-approved program. And taken and passed NBCE parts 1 through 4 or some sort of equivalent, and then been actively licensed and practiced in another state for at least 5 of the past 7 years immediately preceding the submission of the application. That 5-year kind of follows what we had in the prior regulation around that whole 5-year period, but we do want to entertain some discussion around that, whether keep it, change it, remove it, and things to that effect. The remainder of the language just kind of spells out what an application process would look like, which is very, it pretty much mirrors what we've put together for the temporary DC licenses that we're already issuing to military spouses and domestic partners. This regulation itself, as far as a conceptual level, looking at fiscal impact, would be rather minimal. Because the reason being we already have a temporary DC license type that we established for military spouses. So we would be using that same exact license type. So we wouldn't have all the IT costs of having to build a new license type. We've also got in there, and for committee discussion today, the issue of the public notification requirements when somebody's practicing on that temporary license issued under these provisions. And then also just built in a practice restriction if somebody hasn't completed their physiotherapy coursework and training, restricting them from doing it unless they're supervised by someone else. We can add, delete, amend any of that, but just want to turn that conceptual idea over to the committee for some discussion and input so that we can refine it further.
Great, thank you. Ms. Cruz?
I'm looking here, I was looking within it. Is there a length of time that they are allowed to stay within this status?
12 months.
12 months, is it just 12 months? Okay.
Very similar to the military or the temporary license, it would expire after that. The goal was to try and give them some time to get those requirements done, but that it wouldn't extend beyond that.
Yeah, no. Oh, when I was looking back at our prior notes and kind of what was in the language, no, it aligned fairly well, but nothing really sticking out for this one.
Okay. I mean, I like the outline. I think it serves the purpose of reducing the barriers of getting people who want to come practice in California, yet it still will safeguard and align with our curriculum requirements. I'm not really sure how else, to do it besides this pathway. So I thought the draft of the language was in line with what we talked about. And I think you addressed this in your opening comment. One of my concerns that we need to address is the possibility of certain states dropping national boards. And so I think you mentioned a little bit of that language, but I just want to put it on the record. I think we need to be really clear and have some really clear language around the NBCE and or equivalent, and then we will have to come up with what does that equivalent mean. So there is a bit of kind of work to do, and we would want to come up with that so that the board and future boards and staff know exactly what that means. And I'm wondering if the practice restriction should kind of cover not only the physical therapy, I like that language, but if in their public notice, it says, practice restrictions, and then it just lists all the areas that they're deficient. I think some of the main ones that come to mind are obviously PT, but dermatology, psychology, and pharmacology. I think those have sort of been dropped from CCE and not explicit, but they're very explicit in our act. And so an example of my concern would be, the reason that we want to keep dermatology for the stakeholders of California is chiropractors see so much of the skin, and they need to be knowledgeable as far as lesions or things that need to be addressed from a specialist, a dermatologist. And so if they don't have training in that we could document, the patient goes and sees them and they're giving them advice like, oh, don't worry about it. It looks fine and it's not fine. I don't know if that line of thought sort of makes sense of where I just want to tighten it up. Like we wouldn't, if they didn't have those curriculum requirements, we would not be wanting them to give advice in those areas. So I see it sort of as a practice restriction in a sense where, like my current practice restriction is, I can't give advice on medications or drugs because I don't have a medical license. Now I can help have a conversation and guide somebody and give them information, get them to the right person, but it's not on the DC's license. Is that making sense, Kristen?
It does. Yeah, that's a really good, yeah, that definitely makes sense. And it's a really good suggestion.
And then the 5-year, we can't really find, it's in our regs, right? So if we keep it, it's consistent with that. If we try and drop it, I don't know if we need justification. I don't know if we need that in this instance. I think we need to hold that for being a preceptor, because I do feel that you need experience before you can teach somebody else. And so in that area, that 5-year makes sense. The 5-year, does it show us that they don't have any enforcement issues? I mean, it could happen at 5 years and 1 month. It could, so, I don't know. I think of the reality of, say, someone graduates in another state, their circumstances changes and they want to come to California right away. But then we would be saying, well, you have to be practicing for 5 years to come. And I don't want to create that barrier unless I'm missing something.
Yeah, it becomes a policy decision on how we want to approach it. The thought behind having some level of like years in practice comes from just giving us at least some limited information that they've been in practice without any action in another state. It also kind of serves as a tool to prevent like any type of circumvention of our California requirements. Because I mean, if you had nothing, you could potentially, the only thing is I could potentially see some sort of model where it's like all the schools kind of drop all the California requirements and they just tell everyone, go get licensed in this state and then transfer over on a temporary and go get your education somewhere else. So that was the only two kind of points that came to mind as I was looking at it.
Okay.
But
I mean, would 12 months, 24 months, would that sort of deal with the educational portion?
Yeah, it definitely could. I mean, we don't have to keep it with 5 years. We would just have to pick a different number. We would just need to justify how we came to that number.
I mean, I'm not
So-
opposed necessarily to the 5 years, but then I think, okay, well, in actuality, how is this going to work? And then we have, say, a new graduate from Florida. They want to come to California. They got married or their parents are out here and they need to move. Then we've kind of created a barrier. So I'd just like to give more thought to, we want them to meet the California requirements. And we obviously want to make sure they're safe, but we also don't want to overly, prohibit them. Like I said, I'm 5 years, I'm on board for a preceptor, because you need some substantial, but we see people who have enforcement issues after 15 years, 20 years.
Yeah.
So as far as the enforcement part, I'm not sure 5 years does anything. And I don't see any literature on that unless you have, numbers or what other states are doing. But I see your point as far as the curriculum aspect. So maybe we modify the time period to shore up the curriculum issue. So that's kind of my thought on that issue.
Yeah, we'll definitely take a look at that and then kind of weigh the pros and cons of both so we could figure out how to proceed with it. Because the other kind of thought that maybe comes to mind is like how long is a residency program in chiropractic, and maybe make that the time. So then you have something that you're justifying. You're saying they're basically have been in practice the equivalent amount of time of a residency. Or you could entirely drop it and then instead hold the schools accountable, because we do have in the language the schools to be board approved have to offer a curriculum that meets our requirements. So if you removed it entirely, they still have to make that curriculum available to the students, and then it becomes the student's decision. It's like if they don't take it during school, then they have to go through this temporary route and they have a year to make up the deficiencies with the public. So I mean, maybe we don't need it because we're covered that way by holding the schools accountable for teaching those subjects.
Well, definitely, think it over in that term and then see if it will work or not work, as far as kind of that time period. The other is, it could have been in the document. Do we have an appendix or something that says if you do meet all the requirements that are they filling out a different form? Like, how are we handling the actual doing of it?
The of applying for the temporary license?
Correct. Like, yeah.
Yeah, we've spelled that out. It will become a form, but we've taken that strategy where we don't create the form for the regulation. We just specify the requirements. The one kind of potential gap that's not fully spelled out is how you get from the temporary into a permanent, besides just fulfilling the outstanding requirements. We didn't build that in the temporary military licensure language as well, but I mean, we probably should add a paragraph explaining, how they submit any of the deficient items to get themselves to a full license. We'll kind of close that loop in the language.
Yeah, that would be great. Ms. Cruz, do you have anything else? I had something, but I lost it. Go.
No, I like the idea of if we were to consider still with the whole 5-year thing, if you were still to consider having it be years, having it relate back to a residency program is at least the length of a residency would be considered. But I also see that we're also giving them a year to complete it when they're here. So I can go either way, but I agree with you, Dr. Daniels, that it can easily be a barrier just for people to come here and practice.
Yeah, I'm just thinking of people, like I said, if their parents are here, they're
Life
older,
happens.
they want to move, or, vice versa, or, just especially nowadays, it just seems like things change so much that, 12 months wouldn't be terrible. So I'm kind of hovering around there, or 6 months or something that gives us some guarantee, but I just don't see the 5-year giving us any assurance as far as safety issues, because it just seems like you can be in practice for 20 years and then have an enforcement issue or a year. And honestly, I feel like the majority of the students coming out of practice are actually safer than the ones that have been in practice. So when I look at the literature on that particular portion I don't really have anything that supports that. Newbies generally do everything. Their exam skills are, top notch. They have some studies in medicine. The longer a general practitioner is in practice, the less skillful they are, because they are not really practicing all of their skills, and the newbie kind of has all those exam skills right at the ready. So you could argue that newbies are safer, at least as far as diagnosis, treatment, that sort of thing. So, but I hear you on the curriculum. So let's see if we can look at that and figure out the process. Also, we'll need to, I mentioned it at the beginning, we'll need to do some work, and I'm happy to do it offline, on the specifics, really, how is staff going to check the requirements, which ones are deficient easily, efficiently, without having this cumbersome amount of documentation to get through. So schools are changing curriculum, they're changing the way things are said, they're changing what the name of classes, and that's going to make it a little more difficult for us to tease out how much dermatology, how much psychology or mental health that they have, how much pharmacology, because they're integrating it vertically, versus that horizontal progression where you have dedicated classes. So I see that as something that we need to talk through and decide, okay, how are we going to have staff be able to say, yes, you meet those credit hours?
Mhm.
And just to briefly respond to that, just to kind of get you kind of thinking of some ideas there, with the current process, and then even as it was envisioned with the new regulations, the school themselves provides, along with the transcript, they sign a certification basically breaking down the hours for the students. So I see it at more of a high level that maybe this committee needs to evaluate, the different schools and how they're basically doing their math to come up with the requirements and making sure that that system is sufficient. So that way we can trust the certifications that are coming down from the schools, because we're not, unlike some of the other programs, we don't do we don't do like a transcript level review. We have the transcript, but then we're relying on the certification that comes directly from the school that they're attesting that the applicants met those requirements. So I think it might be a future item for this committee to kind of assess the system itself to make sure that it's meeting the regulation.
Yeah, that's great. That's helpful. Thank you. I think the high level assessment of the school's certification of the requirements is a great idea. Yeah, I think that was all my notes on that. I love the draft. I love the idea. So I feel, do we need to do more work than me making a motion right now to put this to the full board in January? Where are you feeling as far as the discussion, or do we want to make a motion to move this to the full board, but obviously with the working on the discussion that we just had?
Mhm.
Kristen, any thoughts on that?
As far as staff, we're probably ready. I would say the outstanding item is the weighing the pros and the cons of do we want to have a practice requirement in effect or not. The thing that comes to mind as I was kind of thinking through those points is if you were to remove the requirement for any type of years in practice, then you're potentially then looking at would it make more sense to have a temporary license available to any graduate that has passed the boards and has a degree from a board approved program, but is deficient in educational requirements? Would we allow all of them in? Because if you're not putting some sort of practice requirement, it's not really relevant whether they're licensed in another state or not, because we'd still be doing the background check. So maybe that's a good kind of item to develop the pros and cons of each, and then maybe get some board input so that we can build it one way or another. Because you're either going down the path of a temporary license for people that are licensed in another state, which is how we've kind of drafted this, or you could be broadly looking at a temporary license for any graduate that's met those minimum requirements to be able to get into practice and then meet any deficient education. So that's just kind of.
I like when you say it, I like the latter, barring any problems with it. You know, when we look at, you know, medical, you know, you can go to any state. VA is looking at sort of the same thing for chiropractors being able to go across state lines. So I don't know, the latter that you said seems more progressive and more streamlined, barring any of, and reducing those barriers, but obviously making sure that we've taken care of the concerns. So that's just kind of my bias when you say that. I think that would be the most, I think, like contemporary progressive approach as far as what other people are doing. So can we, can I make a motion for what we have and then add that staff will also add the pros and cons so that we can have it for the board meeting in January, or how should I handle that?
I'd say it's appropriate to recommend that this regulatory proposal incorporating the discussion here today be moved to the full board for discussion at the January meeting. Sabina can certainly correct me if I'm wrong if I didn't get that motion.
No, that's perfect, because we're going to recommend it for consideration for the full board, incorporating all of the discussion here today. And I think it'd be a great idea to go ahead and look at how other boards handle this kind of thing, and to see if there is a difference, pro and con, into making sure somebody's already licensed in another state versus just the graduate situation.
Perfect. And then can I say so moved?
Yes.
And is there a second?
And I second.
Okay, great. Moderator, can you open up this agenda item for public comment, please?
This is the moderator for members of the public on WebEx. If you would like to make a comment on this item, please click the raise hand icon, or if you're an audio only participant, you can raise your hand by pressing *3 on your device. I'll pause a moment to allow the public time to access these features and submit the requests. All right, and it appears there are no requests for public comment on WebEx.
Okay, great. Thank you. Ms. Cruz, will you take the vote?
Dr. Daniels?
Yes.
Ms. Cruz? Yes. Motion passes.
Great, thank you. Okay, moving on to agenda item number 6, review, discussion, possible recommendation regarding the regulatory proposal to update the requirements for filing places of practice with the board and notifying the public of licensure at practice locations and in mobile settings. Ms. Walker, you are up unless you want me to do it.
I'm happy to just briefly introduce it. So what we've got in the meeting material, so a little bit of background, the committee's had a few discussions around filing places of practice. There was also one of the older Consumer Protection Enforcement Initiative proposals was around notifying the public of the fact that licensees are regulated by this board. A lot of the other healing arts programs have all adopted some pretty standard language that's a requirement to post a notice that, you know, say dentists are licensed and regulated by the Dental Board of California. You may see some of those as you're in different offices. This committee had a bit of a discussion, and the issue is those are helpful, but they also can be redundant to licensure posting requirements. So we had talked about incorporating that statement onto the license itself, so that when you post the license, it has the notice there that that licensees are regulated by this program. That's something that we're going to be working with DCA's Office of Information Services to actually update the template for the license and take care of that. The committee also talked much broader about incorporating some sort of filing of facility level permits. The blocker to that at this point is that we don't have any fee authority for any facility level regulation. So we will try to pursue that type of authority through sunset, which would likely then not be in effect until January 1 of 2027. We'd still have to build out the requirements from there. So where that leaves us here today in December of 2025 is we really should take some action on getting the public notification of licensure regulation moving along. We've also talked about what you do when you're in a mobile or a temporary practice setting. So within the meeting materials that we have for today is a much smaller proposal for us to, one, clarify the requirements for obtaining and then renewing a satellite certificate. Currently, our regulations just say you have to have one, but there's no language on how you get one, how you're eligible, what that process looks like. So we've built that out in section 303.1. And then we've worked on the language for 308 to provide that notification in whether it's at a chiropractic facility or like in a temporary setting or in a mobile setting. So we spelled that out there about how you provide that notice to consumers in those different settings. The committee did also talk about, as it relates to mobile practice, at one point there was a discussion around having language requiring that they comply with all local ordinances for operating a mobile business. At this point, that's unnecessary because the enforcement committee is working on a much broader proposal around licensees being responsible for ensuring that themselves and their conduct complies with all like other laws that are applicable. So it's going to fall under that proposal. So we don't need to spell that out. So for what we have here today, we have section 303, which is outlining how you obtain and renew a satellite location. And then we have a conceptual proposal here on what notice to consumers could look like for a facility, mobile practice, and a temporary setting. So really looking for some input from the committee on this proposal. I'd say this one's developed out a bit more than the one that we just discussed under agenda item 5.
Okay, thank you. One of my notes was place of practice. You have a short term, but short term is very vague to me. I'm trying to find exactly where it was, but it was in the language as far as the temporary practice. And I feel like that could be a problem of people defining what short term is. Do we need to define what that is?
Very likely, yes. This language hasn't gone through legal yet, so they always kind of help us with those kind of terms too. Because it's we will need to spell that out.
I see. So if I heard you correctly, just to review, I understand that we need the legislative approval in order to have a fee to do a change in the facility. But what we have before us, like one of our concerns was really, at least mine, was that mobile, going to a sporting event, going to somebody's house. And so this has the redefinition of any place that you are performing chiropractic care is what I saw.
Correct. What this does is, so what 308 does is require, because currently licensees are required to post a license or a satellite certificate at like a fixed place of practice.
Right.
This requires basically that they're providing the notification to consumers by making that license information available through a posting if it's a fixed place of practice, or if it's like a mobile setting, giving them options on how they comply, where they're either displaying the information for consumers or they're providing a verbal or written notice to the patient. We put that in there trying to be inclusive enough to include when they're substituting for another licensee who's on vacation, so that it's not overly burdensome. Because you think if you were to be temporarily in somebody else's office, giving them additional ways to comply. But yeah, that's kind of what this proposal does, is it broadens it so that everybody practicing has to, in one way or another, provide notice to consumers that they're licensed. so it kind of fills that gap.
Yeah, and I guess when I read it, I had, the sense of wanting it to be stronger language as far as, I mean, it could be fine to how it reads to other people. I mean, one of my main things is that they have to actively provide it so the patient does not need to ask. And so I just want to make sure that I believe I read that, but it just didn't. If I was a licensee and I wasn't really paying attention, I just kind of skimmed the document. I don't know if I would pick that out. And so I think one of the things that Ms. Cruz and I were concerned about was, the patient not having to ask for that pocket license, not having to ask, right? So that they are required wherever they go that they have of those 3 forms, and before they do anything, it's out in the open.
We could look at the way it's worded, and maybe we could put a little bit more teeth in it if we want. We put the language there about it being in a conspicuous location, accessible to any current or prospective patients. I can kind of work with legal on some ideas that are clear, but then also really drive those points. I would say there's going to be the language, the way it's written in a regulation, but then also when we're putting information on our website about like licensees and how they comply with it, it'll be written in a little bit more like plain language where it'll say just that, like you need to post your license so that it's clear. I'm not really I'll have to look at it. If we use words like prominently, if you have to define what prominently means and things to that effect, but we can kind of work on that
Yeah, I think that was my only thing when I read it. It was like, I don't know, it just seemed a little vanilla, and it just didn't really stand out to me that, I, as a licensee, am absolutely responsible. If I walk into somebody's home, I go into somebody else's office, I'm out at a sporting event, the first thing I'm doing is pulling out my license or the QR code or, whatever it is, but that is, before anything happens, that needs to be out there for the patient. So they don't have to be looking for it, asking for it. So I don't know if there's anything to do about that, but that's my only pet peeve with it, especially, I mean, because this is really about, patient safety, and, we don't want to increase the load for them if, they have trauma or whatever. They shouldn't have to think about it, look for it. And I just want to make sure that we have the teeth that it says, this is your responsibility to make sure that they see it.
Yeah, we'll definitely make sure that we're covered there with that intent. We can also, if we don't put it very specifically, we'll work on the language either way, but we can also make sure that intent is loud and clear in our initial statement of reasons that we put forward, justifying the regulation and the need. So that way, when you look at the whole regulation record, you have not only your text, but you can clearly see what the board's intent was behind implementing the requirement.
Yeah, because the word conspicuous doesn't, every time I read it, I'm like, I don't know, that just doesn't, land with me personally. But Ms. Cruz, any thoughts?
No, I agree. Conspicuous yeah, because conspicuous is not the word prominent, right? But then I know we have to kind of get a lot of those terms cleared by legal. But I do at least appreciate the kind of the addition of that kind of 1 subsection C of kind of including the QR code. We discussed that last time. And I definitely hear you, Ms. Walker, in terms of, right, if it's not in regulation, it could be in the kind of board's intent statement, but it can also be in kind of in our practice documentation of, right, on whether it be on our website, but I also see with new social media opportunities that we've discussed, right, what are some opportunities there in terms of especially as we get into, I'll say, different sports seasons and different kind of health fair seasons, right? Having that information available.
Sabina, did you have any input on kind of what I wanted the intent to be in the language? And
Absolutely. I think, well, all of this is a great discussion. I was trying to pull up, in terms of our previous discussion too about temporary practice, there's a couple boards that do temporary practice allowances or a temporary, I think it's called temporary practice allowances. And they actually define them by a certain number of days. So,
Okay.
consider that like for someone to continue treatment or someone who's covering someone on vacation or, so you might want to look at something from, I know BBS did one recently. And I think psychology might have something like that too. But something, it kind of goes a little bit here and in the previous discussion, because here you're also talking about somebody potentially operating the practice temporarily somewhere else, right? But I think letting this, I know I'll defer to Stephen, but hearing this discussion and then having being able to go back through and rework the language, I think the regulatory council and legal will have some good language for you to consider next time, or the full board.
Okay, great. Thank you.
Also, since we have the attorneys on the line, but not to put them on
Yeah.
the spot, because I always have the same take on the word conspicuous, but I think, correct me if I'm wrong, but I believe the legal definition of the word actually is like making it clear, but maybe one or two of the attorneys could tell us what the word conspicuous means in a legal context.
Sure, I'll chime in. OAL standard for clarity is just if it can be interpreted in multiple ways. So if a member of the public can interpret a regulation or a word in two different ways, or then it doesn't meet clarity standards.
Sounds good.
And the
Yes.
and the good thing is there's been a lot of regulations recently going through that probably used similar words or that word. And so I know that Stephen will have those at his disposal to kind of see how other boards have handled using these type of words.
Okay, great. Thank you. So I feel like this one's like agenda item number 5. Do we have enough to move this to the full board for discussion, or do we want to work on this one a little bit more? What are your thoughts?
Personally, I'll defer to Stephen. It's not my regulation, but I think it needs a little bit more work just to kind of go through the language a little bit more. But again, I'll defer to Stephen.
Yes, I agree with Sabina.
Okay. So I won't make a motion on this one. We'll work on it a little bit more. And then moderator, can you open up agenda item number 6 for public comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click that raise hand icon. Or if you're an audio only participant, you can raise your hand by pressing *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, great. Thank you. All right, so we'll move on to agenda item number 7, which is review and discuss possible recommendation regarding the regulatory proposal to establish minimum standards of practice for virtual care. And you can open that up, Ms. Walker.
Sure. So what we've got today, so the committee previously had discussed the issue of telehealth and the need for providing standards within regulation for clarity and for implementing the statute that authorizes licensees to practice via telehealth. And then we've also weaved in a little bit of the committee's discussion from the June meeting as it relates to AI and Gen AI technology. So what we have in the meeting materials is a very conceptual regulatory proposal to create standards of care for virtual care, which we're defining as being broader than the issue of telehealth. We've got the language for discussion there today, but basically we're broadly defining virtual care, clarifying that any person practicing chiropractic through virtual care with a patient physically located in California must be actively licensed by the board, establishing those standards, specifying the requirements for obtaining the patient's verbal or written consent for the use of virtual care, which is required by the statute, Then also requiring that they take reasonable steps to secure the transmission of the data and immediately notify each patient of any type of breach or unauthorized disclosure. And then also clarifying that licensees are responsible for exercising the same standard of care when practicing through virtual care as with any other means. So yeah, like I said, we've got pretty broad conceptual language there in attachment number 2. What it really is a combination of the discussion and looking at what the acupuncture board has out right now. I believe it's either in public comment, but it's somewhere in the regulation process. Acupuncture board has put something out on telehealth for acupuncture. And then we've also incorporated some of the requirements that we've seen with like the Texas and Florida chiropractic boards, and then incorporated a bit of the committee's discussion around the issue of virtual care, and weaved in a little bit there on artificial intelligence type technology. So kind of putting that one out there and looking for some input from the committee on the proposal.
Yeah, thank you. I could see kind of all the work that you guys had done and the different aspects. So, I mean, overall, I think it looks great. I do have sort of a bunch of questions or talking points. And I really appreciate the expansion on the clarity between telehealth and virtual care. And really kind of shoring up that gap as far as the mobile apps and all of that. I'll just start off. My first question was, what about patients in other states? It says patients in California, but we will have a DC that's licensed in California with a patient in a different state.
They would have to contact the state where that patient is, right? So just like any other profession, to make sure they are in, it's okay. Basically, it's okay with that other state. You know, is there a temporary practice allowance there? Is there a reciprocity kind of situation there? I don't know.
Okay.
You know, I don't know the standard right now with chiropractic boards, but you know, we always tell our licensees to make sure you check in with the other licensing boards where your patient is located.
Yeah, so I thought that was the answer. I just see it as a huge problem, and I don't know if there's anything to do about it. I know medical, it goes by where the person is licensed, not where the patient is. And there may be nothing to do about it, but now since post-COVID era, the likelihood of people having patients from California that have moved to another state that would require a consult or, something like that via telehealth. A lot of people are practicing being able to diagnose using these mobile apps. And so if we have to have the licensee check with every single state that they potentially are having patients in, I don't see that happening, which can mean an enforcement issue. At minimum, I would think that, is there anything to do as far as establishing like more specifics for people providing telehealth with a patient that's outside of California?
I think that's where it falls outside of our jurisdiction, because it becomes, some states have established things like licensure compacts where they'll, which we don't generally recommend, just because you lose a lot of control over regulating your own profession and setting your own standards. It's probably a good discussion topic for something like at the FCLB level with the other states and how they're kind of addressing it. But when we look at enforcement, we're looking at where the patient's located. So everyone that's providing any type of care to a patient physically located in the state of California is considered to be within our jurisdiction. So if we've got a bunch of out-of-state licensees providing virtual care, basically over state lines into our state, that becomes our enforcement issue to deal with. But if we've got a California DC that's, say, providing care to patients in Nevada and Arizona, if we get that complaint, we ship it off to Nevada and Arizona for them to deal with, because we actually don't have jurisdiction over it.
Okay.
Right. And then if it's something we can take action based on discipline by another state board, then that's a different story, right? But, it's very hard to control people, the individuals reaching out of the state, until we get notified of something.
And is that really clear on our website?
No, that's going to be included when we get the new content up there, but no, it's not on there right now.
Yeah, I think that's super important because I see many people not understanding the line or the jurisdiction issue. And so I think we really need to facilitate knowledge around that. Because many people will have a patient for 10, 20 years, they move to a different state. I can see a licensee not even recognize, they have a relationship, et cetera. So I think we need to kind of help educate licensees around that. Okay. So are we requiring any documentation or some sort of declaration statement under that section where it says the DC has decided that the chiro care is clinically appropriate? Like, it didn't seem, when I read that, it didn't seem that there was a clear requirement, and maybe there isn't one, but how do we know? How do they know? Is there a declaration statement by the DC in the note saying, I've reviewed the history, the exam, and chiropractic care is appropriate, and then they initial it? Are we requiring that, or how would we deal with that if that came to an enforcement issue?
The way it was envisioned was that it would be the documentation would speak for itself. So you'd have the documentation of the patient visit, and based on like your documented history, your assessment of the patient, whatever diagnosis was there, and whatever treatment was rendered, the document should speak for itself that it was appropriate for virtual care. Like, you certainly wouldn't have somebody that's had like an emergency kind of situation, but then it says that you attempted to provide them with like nutritional advice through a virtual visit instead of referring them out. So it was more envisioned that that they would have to take those steps and it would be reflected in their documentation, rather than adding like an additional notice or something like to that effect. We do have in the language the requirement of getting the patient's verbal or written consent for virtual care. So there's a bit of that, like you would have had to go through the thought process to arrive to get the patient's consent for the virtual care. But if it's something that we need to add, we certainly can.
Yeah, I don't know if it's needed. So I read this twice. I read this as a licensee, and then I read this as a board member. And so I kind of came to not two different, but I had different sort of lenses when I did that. So as a board member reading it, it was like, oh, okay, yes, it's implied. I don't know. I wouldn't mind a conversation or discussion or consideration on a very simple statement. It could close the gap of the DC is saying, I certify, I thought of all these things, I evaluated all these things, and I am certifying it. It would be very clear. Without it, I just feel like we've had documentation issues and things are super vague. So I'll leave that there and we can discuss that. The other is there was a lot of information, and my concern is that it's going to be very easy either for the DC to miss this entire list when providing virtual care, and very difficult, I think, on the patient side to even understand half of what kind of their rights are and what they should be considering. So I don't know if a form submission prior to care, if possible, that included all of this, like the HIPAA compliance, right? I mean, it's just so much information. You have to give something to the patient to so that they can read it and understand it. And if that was not possible because it was an emergency, which could have been you need to go to the emergency room, a submission 24 hours after the care or something like that. And then my other question was, are we requiring all of this documentation prior to each visit? Or is this an initial exam, all of this documentation, all the informed consent is acquired, given both parties accept, and then subsequent treatment sessions within that same examination can be included in that?
Responding to the last point, I think we can clarify it further, but the intent was that you provide the verbal or written consent one time, not have to do it at every single visit. It's kind of the same as what we do with informed consent. As far as the different requirements, there's quite a bit in there to try to cover our bases as far as patient safety. If there's something that is kind of not necessary or just seems like we're piling on, we can definitely delete it. And then keep in mind as well that the intent, especially around us building much better content that goes out to licensees, isn't going to be, hey, we have a new virtual care regulation, read this text and decipher it. We would be breaking it down into much more digestible kind of format that could be easily used as a checklist. But if you complied with that content, you would meet the regulation, so that they're not having to kind of sift through an entire regulation to comply. We would break it down in much simpler steps as far as what they would have to comply with.
Specific
Yeah, I mean,
template.
reading it as a licensee, I guess I sort of missed. It says, disclose to the patient any considerations specific to delivery and receipt of chiropractic services, virtual care, including potential risks, AI, confidentiality, storage practices. I mean, the list goes, I'm not against it. I'm just saying the list goes on. It is a lot. And are we, to me, it wasn't clear. Is this required every single time I do a virtual visit with a patient? Or are we stating some sort of parameter around it? Like, I have an initial visit, I do all of this, right? And I would think the licensee would need to have some sort of form submission that was given to the patient previous, because otherwise it's really not true informed consent, because they're not understanding the data. Is it being recorded by AI? It is, and frequently these people are in pain, they don't feel well. I don't think it's reasonable. I just see a lot getting lost in translation, and then I see it overly burdensome for every single visit if you are doing that every single time. I mean, all this is good. I think we're on the right track. I think these are all things we need to consider. I'm not saying take them out. I guess as a licensee, I wasn't seeing, I read it like I have to do this every single visit.
And
Yeah,
actually, as a patient, I was reading it that way too, to be honest. But what I was imagining, honestly, was just a virtual checklist where I give a virtual signature of like, oh yeah, no, I still agreed to this, and then virtual signature is what I
And
was
that's why I'm thinking of a form, like some form submission
like
prior to
a consent for, a consent template.
but that has all of these things, and that's not always going to be possible. I mean, I have patients call me and it's an emergency. Yes, I can't adjust them virtually, but it is an emergency, and I would not be able to go through all of these things if they're freaking out because they're dizzy. So I could see reasonable within 24 hours after that. Okay, this is our checklist. Just go through this. Do you see what I mean? I mean, there's going to be, we need to protect the patient. We also need to make sure that the patient understands. Like, so for Miss Cruz, like this was a lot, right?
It was definitely, it's a lot, but I would also expect it. But that's just me, right? I do a lot of telehealth personally in terms of engaging with my different practitioners, and so like I can see it be done in different ways. I can see it being done in terms of the initial documentation when I sign up with a provider, right? with all my other, right, where I say I'm opting for the ability to have telehealth. So it's in that upfront documentation, right? So it doesn't have to be like immediately before the appointment. I can see it if folks want to implement it as like part of that online package where they're about to have the appointment, right? But I can also see it, to your point, I'm not sure the kind of more risks with it, with what you were talking about of within 24 hours, right? If it was an emergency to have it. But I can see this being done in a couple different ways, but I definitely do believe it should be a one-time thing and there should be kind of a proposed template.
Yeah, that's kind of,
So,
yeah.
sorry, I provided Ms. Walker a sample of how BBS, Behavioral Sciences, has broken down this telehealth for their licensees and their consumers. So, it's something we can definitely look at. One, how do we do the messaging eventually, right? How do we, for consumers and our licensees, and then also how do we make those requirements really clear in the law? And I know Stephen will do that amazingly. And I don't want to go over in his lane or anything like that. But we have some other boards we can take a look at for samples. And BBS is one who does say obtain and document verbal or written consent at the first, when you begin delivering services or something to that extent. And then they also ask that at every appointment after that also to clarify and to confirm where the person is located to confirm that they, well, there's a lot of reasons why they did that, but there's a bunch of other things that they implemented recently. And so, and I know other boards have also. And so kind of like the previous item 6, we can also look at some other boards, how they handled it. So we don't have to reinvent the wheel also.
Yeah, that's great. Thanks, Sabina. And because I'm looking at this as operational, how do we operationalize this regulatory language? And, we need to have it, but we also need to be able to efficiently operationalize it. Otherwise, we're just going to have a slew of problems. And so, stating specifically the initial visit, subsequent visits could be something like Sabina said, state your location and do you still consent to what we consented to, on your initial thing. And so you're re-asking the question, but you're not going through, the litany of items. And then again, I don't know if we put, prior to the visit or during the visit, if we want an exception, if it's, we have an emergency exception, I think in one of our other regulations as far as notifying them of who you are. I think a 24-hour time period is reasonable for the DC to kind of get that taken care of, or at least get some documentation. Like, say somebody they called and they're dizzy and it's not BPPV and you tell them you need to go to the emergency room. Well, they may be in the emergency room for days, weeks, and so you're still not within that 24-hour going to be able to get sort of that consent. So I just kind of want to think of it in real life and the real patients that we have in those situations, and then how do we protect them and get the DC to do their due diligence. Oh, and then do we have, well, we're going to talk about it. I'm going to put it on the agenda, but informed consent for telehealth different than informed consent in your office, and then different from informed consent for AI. There's a lot of informed consent that we need to clarify. We need them, but I'm feeling that we need to. So I didn't know what your thoughts were on that and how it was written in the language.
So we could definitely expand on it. The way it's intended is to build on each other. So everyone needs the basic chiropractic informed consent requirement of 319.1. Everyone has to do that no matter what you're doing, whether it's virtual or in an office visit. This is meant to layer on top because the statute requires verbal or written consent for the delivery of telehealth, or which we're terming virtual care because we're broadening it up a bit. We could probably weave in a bit around having them consent to the use of AI. I think this was more written in a way that you make them aware that you're using it. But if we want to have like an informed consent around AI, we can build that in here as well. But yeah, that was the intent. So it's supposed to be kind of building on top of each other. So if you're traditional in-person practice, old school pen and paper is how you're taking notes, you have one informed consent requirement. If you've got a very kind of thorough practice where you've got all sorts of different things going on, you may potentially have to provide 2 to 3 informed consents.
Yeah, and I think, and again, we won't talk about it much here because it's not on the agenda, but a separate AI informed consent, because that is a whole different pathway. And there are people that may consent to the virtual care, consent to the initial chiropractic care, but will not consent to any use of AI, say like Zoom recording it. And so there are specific steps that you have to take to delete AI from that Zoom meeting. So I just think they need to be delineated, because one may say, yes, I want virtual care, but I don't AI, and other people will say, give me both.
And there's certain platforms that are secure, right, to even have these telehealth sessions on also, right?
Yeah, that's good.
You know, that's something to take into account.
And I think the way this was initially written, but totally correct me if I'm going down the wrong path on it. With the very, very broad definition of virtual care, it includes AI and Gen AI. So that's why we've kind of weaved them together. But it sounds like from just organizing the regulations themselves, you may have a standalone with virtual care, clarifying that it includes AI, but then having maybe a standalone section on AI. Because I don't know that, and maybe it's just going to be more of a licensee educational kind of thing, but I don't know that licensees that are only practicing in person in a physical office are going to make the connection that, well, if you're incorporating AI tools into your practice, you potentially may need to comply with some of these provisions. So I think we might have to look at how that overlaps for somebody that's providing both virtual and in-person care versus somebody that is only in person, but maybe is utilizing certain virtual tools that actually put them in the realm of virtual care. Or if they're monitoring their patients remotely using a some sort of device, they may or may not realize that this would also include them. So maybe we have to look at
For sure,
where those lines are.
Yeah, like I know that is the case. Like there's mobile apps that you can use that people will have their patients track, get diagnostics from them. And then, a lot of the EMRs have AI embedded, and I'm printing off a separate AI consent form. But yeah, I think we need to make that clear.
So I think, so I think keeping in mind with that too, because I think with a lot of this, the way it was structured, we borrowed a bit from Acupuncture Board, but theirs was much more narrow because they're looking at just telehealth. So it may also just be a matter of obviously clarifying like certain things, because that was the intent, was that you get these consents on the initial visit, and then you only have to provide an updated consent if something changed. Like if you initially didn't get the consent because you weren't using AI, and then you integrate it into your practice at that first visit after you've made that change, you need to get the consent. So we'll make sure that's clear. But we may need to look at a little bit of just the organization of the different paragraphs and stuff so that they fit a little bit better into what we're trying to build.
Yeah, I mean, I love the idea, I love the outline. I think we're like on the right track, but again, operationalizing it and then taking care of that gap as far as in office with mobile apps and AI. And I think we need to do a little bit more on that. Ms. Cruz, any thoughts?
No, it's a lot of information.
Yeah.
And it does get, I would say, yeah, I definitely share app information with my providers too. So it's a lot, but
Yeah, and I know, like I've done some virtual care as a patient and AI in the room, and no one is doing it well as far as following all the steps, informed consent, all of that. So, I mean, it's not an excuse not to do it. I just think we have to look at in that day to day of what's happening with the patients in those different scenarios and how we can efficiently get it done and have the information really clear.
Yeah, I would say clear to the point where it's, hey, we're using this tool. This is how we use this tool, and this is how you're going to experience it. Right. It's just that's the equation of the language, right? For it to be clear, because I mentioned before in appointments where they tell me, oh, I have a little pin here thing that's going to be recording this. Are you okay with this? And I'm like, yeah, right. But that's the end of the conversation, right? There's no document telling me that they are recording it to take down the notes, right? It's not telling me what of that information is going to go into any kind of communications. It's not right. Like,
that's my point. It's just, I mean, it's not just us. It's just not being done well across because when you're in the day to day of seeing a patient,
you just know.
Yeah. So I just want to see how we can bridge the gap more effectively between what Ms. Cruz is explaining and kind of the big packet of the regulatory, and how do we really connect those and streamline them and not just have them as words as a regulation, but that people can really do it. Any thoughts, Sabina? Where'd she go? She left us. She's like, I'm out of here.
No.
Okay. She's back. Any thoughts, Sabina?
You all disappeared for a moment, and so yeah, everything was black, and I couldn't hear. I think if I know what you're asking, I think this was a great discussion. I think the board staff and Stephen have a lot to go on to kind of rework the language to bring back, to kind of flesh out all the concerns and see if we can address it, potentially pare it down when possible, and see if if we have to do virtual and telehealth, and how that the AI also makes it very complex.
Yeah.
Potentially.
Okay. So Ms. Walker, if you're okay, I can give an update to the board members on this discussion so that we're sort of bringing it to their attention, but not moving this forward as a motion, as a formal item. Is that reasonable, do you think?
Yeah. Yes, of course. Yeah, we'll keep working on the language. This is a 2-person committee as well, so if we happen to get something that's more concrete, we can always add it to the agenda for January. But otherwise, April's also a great target for getting some final language to the board.
Okay. And I'm, fine with working offline, kind of going through the specifics so we can kind of get that going. Okay. I'm going to open it up for public comment. Is there anything before I do?
Nope, not for me.
Okay. Moderator, can you open this agenda item number 7 for public comment?
This is the moderator for members of the public on WebEx. If you would like to make a public comment on this item, please click that raise hand icon. Or if you're an audio only participant, you can press *3 on your device. All right, it appears there are no requests for public comment at this time.
Great, thank you. Okay, agenda item number 8, items for future agenda items. I have a couple.
Let me see here. I know at least one that I wrote down is, you probably have it written down too, the evaluation of school certification requirements.
Perfect.
Just taking a look at that. No, that's all I got for my notes.
Okay, great. Yeah, I had that one. And then also AI. So we can start building that out, because I think that needs to be a separate regulation or kind of pathway. And then obviously just continuing the discussions of what we've been discussing, but I think the two new ones are AI and then the assessment that the schools are using.
And piggybacking off of kind of the AI one, Sabina, you had mentioned also kind of taking a look at kind of other examples from other boards around right what it looks like for them to operationalize some of this.
Correct. Yeah. And I've already sent some over to Miss Walker, but there are some other samples, temporary practice allowance that we discussed, I think, Agenda 5, and
That's
the
what it was.
telehealth. We can look
For
at
those two.
how other boards have handled it, and, more than BBS, but I know there's others, and I'm sure Stephen might have examples as well. But that way we can kind of take a poll of other healthcare boards and see how they're handling it, and maybe what's coming in the pipeline also for AI, right?
Yeah.
So we can see how that's being handled.
Great, perfect. Thank you.
Sabina, do we have an example from PT? Because I feel like they're sort of similar.
I'm unsure. I'm not their counsel, so we can definitely look into it, and we can scan all those healthcare boards and see what they have out there.
Just physical therapy is sort of the model is, frequently hands-on, but there's much you can do telehealth wise. And so they might be a good board to look at to see if they have an outline or what they're doing as far as operationalizing repeat visits, that sort of thing.
Absolutely. Yep.
Yeah,
Okay,
I'll reach
moderator.
out. I'll reach out to
Go
them.
ahead. No, go ahead.
Oh,
Sorry.
I was just going to say I'll reach out to physical therapy board's executive officer and have a discussion because I'll see what they've got in the works and also what might be going on in that profession.
Okay, great. And moderator, can you open this item up for public comment?
This is the moderator for members of the public on WebEx. If you would like to make a comment for future agenda items, please click that raise hand icon, or if you're an audio only participant, you can press *3 on your device. All right, and it appears there are no requests for public comment at this time.
Okay, great. Thank you. Okay, so anything else before we adjourn? No? All right. Well, I think we have a little side hustle. But thank you, everybody, and have a good afternoon.